I'm a railroad injury attorney, today discussing whether there's a requirement to have a written accident report if you are a railroad worker who is hurt on the job. The Federal Employers Liability Act, or FELA, is the law which governs on-the-job illness or accidents for railroad workers, and that law has no requirement for a written accident report in order to recover. The law does state there is a 3-year statute of limitations, meaning that a suit must be filed within 3 years from when the railroad worker knew or should have known that the accident or illness arose from occupational circumstances. I remember early in my railroad career that there was a $1 million verdict in the Norfolk, Virginia Circuit Court where a railroad worker had never filed a written accident report of any kind. I went and looked at the court file and I noticed that the judge had given a jury instruction in the case that specified to the jury that there is no requirement that a written accident report be filed under this law. But if a railroad worker doesn't file a written accident report, there should be corroboration of the accident occurrence. There should be witnesses or circumstances to verify that event. Now, the second thing I want to mention is that with occupational diseases on the railroad, as one federal court has said, these don't strike with the suddenness of lightning. They're not an event that strikes like lightning. Occupational diseases kind of occur over some period of time before they manifest themselves. There is never the requirement that a written accident report be filed on those circumstances, but the 3-year statute of limitations does apply. These can be very tricky legal questions. If you need assistance, please fill out a quick contact form or call us on our toll-free number. Thanks for listening today.